We acknowledge that Tri-Cities Community Television operates on the traditional, ancestral, and unceded territory of the Coquitlam First Nation. We thank the Coquitlam who continue to live on these lands and care for them along with the waters and all that is above and below.
Good evening, everyone. Welcome to our town hall event. My name is Ben Craig. Our next speaker is Paul Jaffy. Paul is an attorney in West Vancouver. He's got 39 years of experience in general practice. Over the last 2 decades, Paul has increasingly focused on cases which raise constitutional issues regarding freedom of speech and other fundamental freedoms enshrined in our Canadian Charter of Rights and Freedoms. Paul's going to speak today or tonight about how court decisions on DRIP and DRIPA and the Musqueam agreements have been changing the legal and legislative basis of private property and ownership in the Lower Mainland. Paul's always so popular with these events. Let's welcome Paul Jaffy.
Well, thank you so much for telling me what I'm going to speak about tonight. I was wondering. I'm so thankful for being invited here and for actually following on the heels of John's comments. John's group out in Calgary, the JCCF, has just been an amazing organization over the last few years. Has taken on so many hugely important constitutional battles across the country. I'm just one of many lawyers across the country that John's group retains from time to time to fight various battles. And so I'm really happy to see him here and to be part of that group. And theoretically, and I'm going to get to it now, my subject to address with you tonight is probably the subject of what many British Columbians are awakening to, which is an unimaginable, almost like a brain fog reality that the legal system, and we'll get into property rights of British Columbia, that we've always understood and has been at the heart of an organized and structured society, is at risk, if not very much, I would say, under a cloud of great concern. So let me just, we're going to talk about the Musqueam thing, but the Musqueam thing is the more recent in a series of events that ought to have been wake-up calls. In my view, the Cowichan decision in Richmond, we'll get into that a little bit as well. The implementation of UNDRIP in British Columbia was another situation which, in my view, constituted a wake-up call but didn't attract sufficient media coverage for the public to understand what it was about. But basically, what John was saying earlier is that we've evolved into a country, and both in Ottawa and in British Columbia, with very ideologically disposed governments that have taken great leaps towards institutionalizing the differences between people based on various characteristics, race, gender, ethnicity, religion. It's the institutionalizing of these differences between people which is the hallmark of an ideologically driven government that has certain ideological objectives and that compromises our freedoms, the freedoms that we've learned and grown up with and that characterize a free and democratic society. So let me just go back about 20 years, almost 20 years. There was this thing called the Nisga'a Treaty. The Nisga'a Treaty was the first comprehensive land claim treaty negotiated in BC between the feds, the province, and Nisga'a-ism's government. Through John's former group of constitutional lawyers, we acted for a bunch of Nisga'a citizens challenging the constitutionality of the Nisga'a Agreement, which sought to entrench paramount lawmaking powers in the hands of people of Nisga'a racial ancestry over a part of northern BC, carving out a chunk of Canada and making it a third order of government. And we said that this constitutes a constitutional amendment, and the Constitution of 1982 is supposed to be very, very difficult to amend, and the feds and the province and the Nisga'a government was using this thing called Section 35 in the Constitution as a backdoor way to amend the Constitution. In any event, our challenge to the Nisga'a Treaty, which was brought on behalf of a bunch of Nisga'a people themselves that realized that they were the ultimate victims if this becomes the template of treaties across British Columbia. We were acting for them to try and stop the politicians from starting to carve up this country based on these racially based legal powers. In any event, we lost that challenge. But back in 2010, I could read to you, and I won't because I've only got a few minutes, but what we were filing in the courts. And so what we now see emanating from the aftermath of the Cowichan decision in Richmond and this latest thing about the Musqueam deal, we see media coverage exposing concerns about what's happening to this country. Well, we were raising these same concerns back in the Court of Appeal in 2010. We were saying you can't go this way. You were going to create, we called it a recipe for chaos, where you have 50 or 60 different Aboriginal groups across the province, all asserting claims over areas in which they contend to have paramount lawmaking powers. It is an unimaginable mess. It is a recipe for chaos. Those terms were being used unsuccessfully in the courts many years ago. So now we see what's happening in British Columbia with the latest events, which I say are wake-up calls. But here's a few other wake-up calls that didn't attract a lot of attention, and that, in my view, should have. We have the Victoria has transferred lawmaking power to the Seashell Band on the Sunshine Coast. It was all done secretly. There was no public awareness that it had happened. It's a huge transfer of lawmaking authority into the hands of a small group of people who now have authority over thousands of people on the Sunshine Coast who have no capacity to vote for these people or to hold them accountable. It's entirely antithetical to the way a free and democratic society is supposed to work, and it was entirely done in secret, like Musqueam deal. We see the Nisga'a deal that we've talked about. The Haida up in the old Charlottes, Haida. This deal was an agreement between the feds, the province, and the Haida Nation. The whole Haida, the whole islands have now been declared to be Aboriginal title under that deal, even though on the island there's private property interests. There's nothing in the Haida deal that carves out any sort of protection for these people. They are entirely at the mercy of the Haida government. When the Richmond decision came down in August of last year, the alarms went off. It was the wake-up call, which began to attract a huge amount of attention because you have 800 acres of Richmond that have been declared to be Aboriginal title for the Cowichan, and where you have the judge saying that our land title system, which registers interest in lands and creates what's called indefeasible title for fee simple interest, is inapplicable in areas where Aboriginal title has been found. Now, as most people know, claims of Aboriginal title cover the entire province, and in fact, many times over, because there are overlapping claims. So if you take the judgment at face value, even though it was specifying 800 acres in Richmond, you have a declaratory judgment, because it's part of the judgment where the judge said that the relevant sections of the Land Title Act do not apply in areas where there's Aboriginal title. So you look at that judgment, and it's essentially saying that the entire way we've managed our society, and where you've invested your life savings and you think you have security because you have a registered fee simple interest in the home that you own, is a house of cards. It all goes back to the analysis and the judgment. Now, of course, it's under appeal, but you had the Musqueam there, you had the Tsawwassen there, you had the Cowichan there, you had BC there, you had Canada there. what you didn't have in that lengthy litigation was anybody going to bat for the homeowners. And in fact, there was an agreement between the Crown, at both levels, to keep the homeowners out of there, because they knew there was going to be a problem getting where they'd gotten to. And then in the aftermath, you had Eby professing a great interest in appealing, but the reason Justice Young reached the conclusion she did is because of the positions taken by the Crown, which started back in the Nishka case, where they were essentially endorsing this separate sort of nation-to-nation type relationship with paramount lawmaking powers. It all ties together, because when you get to Aboriginal title, and I've only got 50 minutes, we could spend a long time on this, but basically it all ties together, because Aboriginal title is not just an interest in land, it's the land itself. And the theory of it is that colonization of BC did not extinguish what's been found to be an Aboriginal right, which is Aboriginal title. Aboriginal rights are protected by the Constitution, and since 1982, when the Constitution first came in, the new one, the idea of Aboriginal rights is expanded to include Aboriginal title. So the theory behind this decision in Richmond is that the Crown grant, which everybody who owns anything, if you trace it back to the original owner of that, it's derived from the Crown grant. Okay, and that all started in about 1846. I'm being given the hook here in 5 minutes. So, but basically, there's this old Latin phrase, nemo dat quod non habet. You can't give what you don't have. The Crown didn't have the right to give away someone else's property, so the whole land title system, based on the analysis in the Richmond case, is invalid. It's a house of cards, because the Crown never had the right to give away what is now found to be Aboriginal title. So the very governments that brought this mess to us, and they brought this mess to us because they didn't contest, they didn't advance the argument that Aboriginal title had been extinguished. They're professing to appeal this thing now, but it's the very result, which was not just predictable, it was inevitable, based on about 20 years of case law. When the Charter came in 1982, a lot of people were really concerned that it was going to politicize our courts, because it gave huge discretion to judges to decide which kinds of government actions that, although they infringe various rights, are reasonable limits prescribed by law and demonstrably justified in a free democratic society. So it was going to inevitably load up the courts with activist judges, because when you've got governments like Eby's and Trudeau, who are activist governments, they're going to appoint activist judges who share their ideological and political views, and they will interpret what reasonable limits there are to the freedoms that you're trying to assert. So over the last 40 years, the Charter of Rights, which was very meaningful back in the 80s, I was a Crown Counsel back then, and it was taken very seriously, has now, as you've seen throughout the pandemic, the Charter of Rights has become just a distant dog barking, a toothless, almost worthless. And in fact, I would argue it to be worse than useless, because Canadians still suffer this idea that the Charter will protect them. So when they see governments misconducting themselves, they say to themselves, well, it can't be that bad because we have the Charter. But the Charter does not work when governments misconduct themselves. John touched on a couple of federal initiatives which take away the requirement for warrants, which is a traditional, fundamental constraint on governments to jump into your home or otherwise intrude into your personal lives. BC is doing the same thing. We have the Emergency Act, we have the Health Professions Act, we have legislation covering huge areas in which the need for warrants is being continually eroded. And so we see this ideological approach both federally and provincially that is, I think, something to be very concerned about. But let me just, I wanted to, I haven't got to it, but I'm going to try and do that right now. The Musqueam deal. The Musqueam deal was an agreement, it's just a contractual agreement of sorts between the federal government and the Musqueam. It was announced because it had been leaked in late February, and it covers the whole Lower Mainland, and it's called, there was 3 deals. The rights recognition is the one that's most concerning, and what it does is it essentially sets up a framework by which the principles of UNDRIP are to be enforced in British Columbia. UNDRIP, I'll just tell you as best I can in the 2 minutes I've got left. UNDRIP is the UN Declaration on the Rights of Indigenous People. British Columbia implemented it into domestic law in 2019. Otherwise, an international declaration of that nature has no legal force, but when it's brought into our domestic legislation through an act in the provincial legislature, which requires all BC laws to be interpreted and enforced on the principles of UNDRIP, it takes on a whole new meaning. But basically, the free, prior, and informed consent of Indigenous groups is required for any legislative action or administrative action that may affect their interests. So it creates a veto in the hands of, quote, Indigenous people, which is undefined. Okay, it's undefined. A veto. It essentially establishes in areas recognized, and in the Musqueam deal, it shows you that great big map, which, by the way, overlaps Tawasin, overlaps Cowichan, overlaps Squamish, overlaps the Tsleil-Waututh. So you have tremendous disharmony between the various competing claims. But in any event, the Musqueam deal establishes a large part of BC, including Vancouver, YVR, Roberts Bank, Fraser River, areas where any legislative action requires the free, prior, and informed consent of a small little group of roughly 1,400 people, in respect of whom the 2 million people of this area have no capacity to hold accountable, have no capacity to vote for. It is an unbelievable move. UNDRIP itself is an unbelievable thing. And then what was incorporated provincially through DRIPA, which now even Eby is saying he's going to repeal portions or amend portions of DRIPA. He won't tell you what parts, but 3 months ago, critics of DRIPA were being accused by people like Eby of being racist. Okay? Now here Eby is getting hounded by Native political people because how dare he touch this DRIPA? But even he is now saying DRIPA has to be changed. Of course, it's like polishing the doorknobs on the Titanic here. You've got to get rid of DRIPA because all what DRIPA does is essentially enforces UNDRIP. UNDRIP is the most racist thing you could possibly imagine. I know what the word racism is used by others far too much, but it just reeks of the very evils that I think free and democratic societies have to fight so hard against. I know that it's I'm probably on overtime here, but UNDRIP is filled with obligations that essentially entrench a veto on behalf of unknown people. So it allows governments to pick and choose which particular Indigenous people they want to do deals with. So we have the Musqueam deal, but of course the Squamish weren't consulted, nor any of the other First Nations in the Lower Mainland with respect to this deal. Everyone was surprised by it, but I suppose the Feds, and even Eby pretended to be surprised about it, and that was remarkable. Here you have a deal which the Feds say had been underway for years, and Eby pretends that he didn't know about it. And now it's remarkable. And when he was, of course, shown to have been at the ceremony itself, his escape from that inescapable position was, he was there as the MLA, not the premier. This is the it's shameful, and the other thing is this. I mean, I know I'm on board time here, but look, this deal. If you look at the map that was drawn, it's dealing with, I mean, the theory is we have a constitution which is a partnership between the provinces and the feds. You have Section 91, which is federal lawmaking powers, and you have provincial lawmaking powers. Provincial lawmaking powers include property and civil rights. Well, you have trillions of dollars of property and civil rights at stake within the Lower Mainland that the feds decided to declare was subject to Musqueam Aboriginal title in an agreement which says about 10 times that the principles of UNDRIP are applicable and will guide the interpretation of that agreement, which means the free, prior, and informed consent of the Musqueam on any legislative changes that may affect their interests. All of that happened, and Eby will have you believe that he didn't know this was happening, even though this is squarely within the purposes of the provincial legislative powers. And this is the province's premier saying he didn't know this was happening. And if you read the agreement itself, the negotiations theoretically were taking place over 10 years. And the premier's telling you he didn't know about it. And it was all done secretly. It was all done secretly, like the Seashell deal was done secretly, like the Haida Gwaii deal was done secretly. In fact, the Haida Gwaii deal, I'll just finish on this point. My credibility is going to take a beating here, because it probably won't. But when the Richmond decision, Justice Young in the Cowichan case came down, there was such an explosion of outrage that the feds and the provinces could conduct this litigation without public awareness and, in fact, opposed standing for people whose properties were at risk. There was such an explosion of outrage. And then what happened was, the next month, the feds in the province secretly went into chambers to get a consent order that the deal they cut in Haida Gwaii was to be recognized as a Section 35 treaty. Section 35 is the Constitution of Canada that recognizes and affirms existing treaty rights and Aboriginal rights, so it becomes carved in constitutional stone that can never be changed by subsequent governments. So right in this tsunami of public outrage that emanated from the Richmond decision, they went quietly into court without any notice to the public to put into constitutional cement a deal in which all the private interests up in Haida Gwaii, and the rationale for that is that the present chief up there and some politicians down here were saying, don't worry, we're not coming after your private property. Just like the Cowichan's, so the spin machines are working. The spin machine, don't worry. Well, if that's true, and of course it isn't true at all, Justice Young said, Land Title Act doesn't apply. And DRIPA, which is UNDRIP, says that the Indigenous groups are entitled to recover the land or be given fair market value for the land. Okay? So they go in and they do this deal with the Haida, and then Musqueam comes out. All done in secret. And you have to ask yourself, how could this possibly advance the interest, the stated purpose behind reconciliation? It is entirely antithetical to, it is, I don't want to overstate it, but it's more of a declaration of war than it is any genuine attempt to reconcile. Reconcile means understanding and moving towards each other and accommodating each other's interests and doing what we can to get along and build a productive society. This is a declaration of war, and it's a continuing series of events that's taking us in that same direction. And I know I'm way over time, so I would continue, but I just want to say this. Look, to the degree that people like me speaking at events like this can make any difference at all, I'm happy to participate. I'm happy to wake up people to things. I try not to overstate things, but there are some things that are incapable of overstating. And in my view, what's happening to this province is one such circumstance. It's really unimaginable. So I would encourage you to look into these things yourself. Read UNDRIP, and realize that you have a choice between a free and democratic society in which we all grew up and where we cherish these fundamental values, or the kind of society, the kind of race-based society advocated by people like Evie and Trudeau, where one's rights and place in society is based on one's racial ancestry, to ascribe political power and economic benefits, and to institutionalize these differences is a very, very different world from the kind of world where we grew up and where I think we have to start fighting back to protect. So those are my thoughts on that.